This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I may answer your questions. So it's good to be back to be able to take your questions and also talk about a specific topic today. Today, I'm going to be talking about applying for the green card without a spouse or a relative who's mistreating you. So, not only a spouse, but also a relative. I want to get into the specific requirements. So, I did speak with someone who they met all the criteria to apply for the green card without their spouse, except there was one requirement that she was unable to meet. So I think it's helpful for you to also know other than the mistreatment itself, that there are other requirements as well to apply for VAWA. VAWA is what allows you to apply for permanent residence here, your work permit, without the spouse or certain relatives who are mistreating you. And I'll tell you who those relatives are. No, the and I'll Delarue. I'm definitely gonna get into that. So how does VAWA work? So VAWA is the relief that immigration relief that individuals get if they have a U.S. citizen or a legal permanent resident spouse, a parent if you're under 25, under 21, really, but if you're under 25, you may still get this relief in certain cases. And also, if you have a citizen, son or daughter who's age 21 and up and they're mistreating you, then this could be for you. And it allows you to go ahead, stay here in the US. You don't have to leave to get this relief. You don't have to involve that relative or that spouse. And then you go ahead, apply on your own, and you get your work permit in most cases and your travel document, which the travel document, I do this on a case by case basis. And I will tell my clients whether I even recommend they travel. But there is the high likelihood that you'll also be able to apply for a travel document to be able to get the flexibility to take short trips out of the US. Now, keep in mind that the VAWA does have, other than the mistreatment, there are other requirements here. So the general requirements are that you do show the mistreatment. Now, showing mistreatment doesn't mean that you have to definitely have a police report or you have to have pictures of your injuries. Um, it doesn't work that way. So the immigration service makes it very clear that they accept any credible evidence. That means any evidence that shows that's believable, that shows that you went through this situation, can qualify you for this. And this includes a sufficiently detailed declaration. So this, when I say sufficiently detailed, it means that you can't just write, or I do not recommend, nobody will tell you this at immigration service, but they will not they will not approve a VAWA where you're writing a paragraph saying, my spouse called me names, my spouse abused me, my spouse. It has to be sufficiently detailed to to paint a clear picture to the officer about what you went through. This includes showing specific incidents, a specific pattern that you had to endure, where you were subjected to abuse or mistreatment. They call it extreme cruelty. So that's one. However, as long as it is believable, which includes your statement, then it will be accepted as evidence. Now, along with that, they look at other things. And the individual I spoke to, she met all the requirements. She was married to a spouse who mistreated her, who held on to her papers to prevent her from succeeding in her process. Now, That all of that was great. The only other thing that was missing here is that they didn't her marriage was short. Her marriage was very short because of the mistreatment. And because of that, they never really lived together, got to live together formally. They were back and forth between each other's homes, but because of the mistreatment, she didn't was not willing to put everything on the line and live with this spouse. And I do think that is an unfair requirement because you do have spouses, many spouses who are in the same situation where they get married, but then they don't officially live together. And now, you don't have to, with this process, you don't have to show that you are living together as a married couple, but you do have to show that at some point in the relationship, so even before the marriage, you were living together. You were living together even for a day, right? Even for one day, that can count here. Then there is an argument to be made here that you live together. But if you're married and you never officially, um, there was not one day that you stayed in that home, in one home together, that is where you cannot apply for this relief, right? That's where it disqualifies you. Now, if you live together, if you stayed overnight in a location together with the intention of building a life together, then that still counts. Because keep in mind, I have had clients who the first time they moved in with their spouse and they were out within a few days because of the mistreatment. And that's totally logical, right? Because you need to get to safety. You don't want to put yourself or stay in a situation like that. And so that's why it is still possible to apply for this relief if you can show that even if you were together physically living together for a week, or you're staying together for a week, it can still count as residing together. The point where you cannot succeed is where there was not one day that you could say that you officially lived together. Now, I did see here, so does it apply to men as well? Or yes, it applies to men. Yes, absolutely. Um, so I keep saying her. Does it apply to a man if he experiences abuse? Absolutely. I have many clients who are also men, so it qualifies here. Um, it doesn't matter who you are. What matters is what did you go through and do you meet the relationship criteria? Were you married? Did you enter the marriage in good faith? Did you reside together at some point, no matter how brief it is? Did you reside together? And are you a person of good moral character? Now, good moral character, it with this one, it usually means based on the average standards in your community, can you fit within the profile of a person that's a good person, that's an upstanding person? It doesn't mean that you have to be like a saint. It just means that you do have to show that you fall right into the same profile as the average person in your community. So it doesn't necessarily mean that you don't have a criminal record. Now, if you do have something in your past, we may have to work a little harder to show that you are now a person of good moral character. And keep in mind that being a person of good moral character, they look a few years backwards. So they're not looking at your entire past, but they want to know in the last 3 years, have you been a person of good moral character? So having a record in your background is not necessarily going to disqualify you, or having additional immigration issues is not necessarily going to qualify you. Now, this form of relief is available whether you overstayed, whether you came into the country without permission, you can still qualify for this. As a matter of fact, this is here for exactly this kind of situation where you overstayed or you came into the country you're in a vulnerable situation because you're with a spouse who's mistreating you, and you need a way out. Another thing is, even if you have certain immigration inadmissibilities, say you came in with someone's passport, say not a US passport, say you came in with a non citizen's passport, or you use somebody else's visa, then and you came into the country in that way, that can be or is likely to be considered misrepresentation or fraud, unless you're going through the whole reason you did that was you are seeking asylum and you've now applied for asylum. That could be a way, that way to get around that situation. But say you did have a issue like that and it is considered misrepresentation or fraud, there's also forgiveness that you could apply for. So, through the form of a waiver. And this waiver allows you to show that if you have to leave the country, you'll experience extreme hardship. So, this is a flexible form of relief. It's a valuable form of relief. And it's not only for you, but also your children. So, now relatives, it's not just this VAWA relief isn't just for spouses of US citizen or legal permanent residents. It's for other situations. If you are the son or daughter under 21 and unmarried, or you're under 25 in some cases of a citizen or resident, and that citizen or resident parent mistreated you, this could qualify you here to stay here and get your papers. If you are the parent of a citizen and that citizen mistreated you, and now that citizen is age 21 or older, you can still apply for this form of relief. So it's not just for those who are spouses of citizens or residents, but also those other family categories. All right. Thanks so much for the love. I appreciate it. So she can't say he if it's not a man. That's right. So I was talking about a specific example, and this is why I said she, because I was talking about a situation where she met all the other criteria to get relief here, but she did not meet the residency requirement. And that's just one of those requirements that you have to meet if it's even for a day. And in her case, she could not say that there was one day while they were going back and forth to each other's homes. There was not one day that she said that she lived, she resided with the spouse. All right. All right, so I'm going to answer questions. So put those questions in the comments and I'll answer while I do see questions coming in, but I did want to mention this. So the next 2 weeks are going to be very busy and I will not be making my regular appearance at lunchtime. So while I will try to hop on wherever I can in the next 2 weeks to answer questions and come with topics, it will not be on a regular basis as it has been from Monday to Friday. So that's going to be happening throughout June, and hopefully I can get back on schedule in July. But what you can do is make sure you follow me, make sure you subscribe on YouTube so that when I am posting content, posting videos to keep you updated, you'll still have access to those. And when I do hop on live where I can, you can get notification that I'm live. Now, if you want to go ahead and schedule an appointment because you need to speak with me about a particular issue or matter, go ahead and go to the link in the profile. Go to the link in the description of the video, and you will see everything you need to schedule your own appointment or call the office staff. Office staff will always be available to answer your questions and help you to get on my schedule so we can talk. All right. So, what if you are married, but then you're separate and in waiting to hear from immigration? And when you finally do, they need more proof, but you have none to show. What will happen to that? So, if you're in a situation where now the spouse is not moving forward because you're separated, then yes, you are at an impasse. However, where this relief can come into play is where the separation is as a result of the mistreatment, or you were mistreated by this spouse. If that was the case, then you could make a switch from the process you have now to your own process that will not involve the spouse. So that's what I've done for some of my clients when they're in similar situations and they were mistreated. Now, mistreatment doesn't have to be physical hitting. It can be verbal mistreatment or abuse. It can be as anything that they do to control you, right? Anything they do to get you to comply with them. So if they're vindictive, if they hold your immigration papers over your head, which it might be the case here, if they're holding on to the immigration papers and not telling you what's going on, then that could very well mean that they're holding it over your head, and that amounts to extreme cruelty. So that's the solution there. If you are going through the process now, you filed your immigration papers, and then now they're mistreating you, or they have been mistreating you, and now it's to a point where you can't move forward. Make the switch. And I help my clients to do that. You can always schedule your appointment so we can talk about the situation to see if you qualify. I was on filing for over 16 years, and at the end of it, was told that I've aged out and will not be able to go. My mom was told that she now has to go and file for me, which might take another 7 to 10 years. So, yes, there's a special calculation that they have to determine whether someone ages out or not. And if they did apply the calculation correctly and you aged out, then there would be no choice but your mom to go ahead and file for you, which unfortunately, if you're 21 or over, it is going to take a long time. All right, so hi, what are the options for a person whose I-20 end is in a complete status because of late admission after OPT ended? um, is requesting a reinstatement after being out of status for more than 5 months an option? So I'll have to look at your facts. I mean, if you have passed the timeline to apply for reinstatement, then you have limited options. But I want to hear what happened just to see if there's a way to fix the situation. And you can always schedule the consultation because this is a little more complex. I'm over 21 years and unmarried. So, yes, unfortunately, when you're 21 or over and you have aged out, if you don't have other independent options, unfortunately, you're not able to. Um, you have to go through your parent. I don't know what your circumstances are. I don't know if if you're in the U.S. I take it you're outside of the U.S. because if maybe it was in the NVC they told you you aged out. But if you're here in the U.S., I could evaluate your circumstances to see if you qualify for other options. But if you don't, that's going to be your best option unless they change the law here. Good afternoon. I know this is not VAWA related, but what do you do in a case where you have no unabridged or abridged birth certificate and you have applied but still didn't receive and the passport has expired? So it's going to depend on what you're applying for. In some cases, those are required, but if you can't provide an acceptable birth certificate, you do have alternatives. So you have where you can submit additional documents showing where you were born, how you were born, and all the details regarding your birth. And that involves getting affidavits from individuals and records showing your birth. when it comes on to the passport, if you're applying for an immigrant visa, the passport is required. Now, I've had cases where, for example, in Venezuela, when my client was going through the immigration from Venezuela to the U.S., they were no longer issuing new passports that because of the lack of resources that they had at the time. And so what they were doing was like putting a stamp in the passport saying that they would grant an extension. So I got in touch with the embassy, and the embassy in Venezuela at the time, the embassy just, accepted the explanation and made an exception here and still move forward with putting the immigrant visa stamp in the passport. So if it just depends on what the circumstances are involved, what is your country doing right now with your passport to determine what the solution could be. Um, what if they didn't abuse you? Then you don't qualify. So if they didn't abuse you or mistreat you, subject you to extreme cruelty, then you don't qualify. And if there's nothing like that happening, you'd have to evaluate other options. I have 5 years here without a green card. I came with a visa. I have TPS. So I think that's all I'm seeing. I don't know what the follow up is here. How can I have my green card? So you can't just jump from TPS to permanent residence. What you'll have to do is you'll have to qualify in some way, some other way. And that's going to depend on your circumstances. So, for instance, if you got married, if you got married here to a US citizen, then you'd qualify to do adjustment of status. And then again, it also depends on your mode of entry. How did you enter the US to determine whether adjustment of status could be for you, even with TPS? But and right now the TPS, they are making exceptions, or they're creating rules and policies regarding having TPS and adjustment of status. So that is an ever evolving type of law that's happening, or policy that's happening, especially by the different courts around the country. But to go from TPS to a green card is not a direct, you don't just get direct access. Now, there is, for example, with the legislation, the proposed law, the Dignity Act of 2023, which is not law, and we have a ways to go before we even see it becoming law. That does propose that individuals with TPS and those with DACA do get can jump straight into getting permanent residence. However, right now, there's not a direct path like that. Is it possible to just divorce and try getting it on your own? So no, it doesn't work that way. So now, if you're divorcing because you're experiencing, so let me clarify that, because you can apply for this if even after divorce you have 2 years to apply for this, but your divorce has to be as a result of the mistreatment that you experienced. Can an employer sponsor an immigrant that has overstayed their visa for a green card? Short answer is very, very unlikely. No. So if someone is promising you that, just know that at this time it's going to be unlikely. There's one situation where that can be possible, and that can be where if they say they overstay, excuse me, say they overstayed, but say that this person who overstayed, they have a US citizen or a legal permanent resident, spouse, or parent here, then the employer can move forward with sponsorship by submitting the labor certification and the petition after the labor certification is approved. And then once that's approved, it will be sent to the embassy through the NVC. Now, at that point, they will still require the person who overstayed to go to the country for the interview. But before doing that, because remember, if this person overstayed by more than 180 days and then they leave the country, they're barred for 3 years. So definitely can't work. Now, if they overstayed under 180 days and then the interview came within that 180 days, then they would be okay if they left the country before that 180-day mark. However, it's very unlikely that the entire process would be completed within that 180-day timeline. So you'd have to apply for special forgiveness to leave the country and be able to come back without getting barred. And the waiver would be dependent on the extreme hardship of the US citizen or legal permanent resident, spouse, or parent. So that is one way to do it. But as you can see, it's not as simple as an employer just submitting the paperwork and you getting your work permit and moving forward. It's not that simple. It's going to require quite a process. And at the end of the day, you still have to leave the country. Uh, Okay, so can my fiance come back to the US with me once we get married? No. You're going to have to go through a process, and it's probably going to be about a 2-year process. Hi there, Pamela. Nice to see you. VAWA case transfer to Chicago is fast processing for I-765 and I-131 transfer 215 on that date. When is the expected biometrics done? So I can't predict that. You're just going to have to wait in the mail for the biometrics. So biometrics is usually about 2 months after. Um, Okay, so I had reapplied for removal since 2018 before the condition was up, and I'm just now hearing back from immigration. So it is backed up right now. So what I just mentioned here is called removal of conditions. It's where you're going from the 2-year to the 10-year green card, and that's through marriage. If right now, though, removing the conditions is really backed up, unfortunately. Needing proof of marriage, but we are separated. So keep in mind the proof of the bona fide marriage is before you got separated. So once you're separated, they're not requiring evidence after you're separated, but they're requiring evidence before. So this is where it's important, though, to have an attorney, because we as attorneys know the ins and outs of the requirements, and we're able to assist with what needs to be submitted. Because a lot of people, you tend to uh, negate yourself from the process because you think you can't meet the requirements, and that's not necessarily always the case with our with an attorney that can brainstorm with you and come up with good solutions. You can still succeed in the process. Can your husband petition for your green card along with your 19-year-old child at the same time? So I don't think that would necessarily be um no, you're 19. No, can your husband petition for your green card along? Yes. Yes. So if your spouse is a citizen and then your child is 19, you definitely want to get on the ball here and get it going. Your spouse can file as long as you were married to your spouse before your child turned 18. If your child was 18 by the time you got married, then they can't petition for them. So there's no program for people who are looking for a green card without marriage. So I wouldn't necessarily say that, but it's gonna depend on, do you have other family relationships? What's your educational background? Who's your employer? So it's going to come down to what your circumstances are. But there's no program in place that says, do you have TPS? You're not married. go ahead and get your green card. Not right now. Currently, no. How many is VAWA case taking to get approval? About 2.5 years. But keep in mind that in that 2.5 years, you're able to get your work permit, you're able to get your travel document that provides you some relief, and you're able to get your social security number that allows you to work and get started on your life um, while you are going through the process. If I don't respond to them by the time frame they gave for financial reasons, what happens? It's very, very important to get back with immigration. If they're giving you a deadline, you should get back. What's the process of change of status in the US? So it's, to change status. Now there's adjustment of status. That's the process of getting the green card while you're in the US, and change of status. That's the process of going from a one non-immigrant status, like say a visitor's visa, to another status, like say an H-1B. So there's a difference there. I don't know which one you're talking about, but with the change of status, it's going to depend on the visa type and all the whether you can qualify for that jump from one status to the other. But it's done through the I-539 form, and then with the adjustment of status, it's done through the I-485 form, and the end result is going to be the green card. Okay, so no, we did not get married before she was 18. I thought she could be added to my case, and he petitioned for both of our green card. Now, is your spouse a citizen? Because it's yes, at this point, um, if no, here's it. If your spouse is a permanent resident, then you can bring along your child who is under 21 and unmarried on the same petition. If your spouse is a citizen, spouses of or immediate relatives of US citizens, that's the spouse of a citizen, which that may be the case here, I'm not sure. Just please verify that. The child of a citizen who is under 21 and unmarried, and the parent of a citizen, and that citizen is age 21 and up, cannot bring dependents on their application. So if you're being petitioned by a US citizen spouse, you can't you will not be allowed to have a child, no matter how young the child is. If you even have a baby, if the child is it doesn't matter. It doesn't even matter if the child is the child of the father, the US citizen father. I mean, of course, that child can derive citizenship. That's a whole other case. But say, just say for example, this child was just born. It's a child of the citizen who is applying. That child can't be included. You'll have to go and get the child's passport at the embassy to derive citizenship, or the parent will have to sponsor the child. However, if the child, the father, is a permanent resident, then that child can be included on your application without filing a separate application. What about just applying for citizenship instead? It's been over. Shanika, it sounds like you need help. You need some assistance with this process, because you can't um, unless you get confirmation. You can apply for citizenship, but you still need to get your 10-year green card first approved. And there are situations where they apply for the both of them at the same time. And when you go to the interview, they first make sure that you qualify for the 10-year and then jump straight into the citizenship. But I don't know where you are in the process, and you want to make sure you're okay. The worst thing you can do if you're going from a 2-year to a 10-year is give up and not do anything. So give me a call, give the office a call, or schedule your own consultation online, and then we can talk. And make sure you do that soon so I can speak with you as soon as possible. All right, so that's going to be it for me. I'm just going to answer a few more questions and then I'm going to head out. Just remember that I will not be making regular appearances during the lunchtime, so the 12 to 1 o'clock hour. I won't be making regular appearances for the next 2 weeks. You'll see videos. I will try to come on where I can, because I still do want to touch base with you. But please follow me. Please go ahead and subscribe on YouTube, on Facebook, and follow me on Instagram so that you do see when I go live, so we can hop on and have these kinds of conversations where you're asking good questions. So you cross the border and you get a court date. When you face the judge, if he approves you, do you get your work permit? So the first court date is usually not, you're not going to get an answer, an approval. The first court date, you're just talking about the charges in the notice to appear and immigration charges, not criminal charges, and the defenses to deportation. And then about 6 months to a year later, the judge sets the actual court date to do the individual hearing, like which is like a trial. While you're waiting, so for example, if you applied for asylum and it's in court, you can still apply for your work permit, but you just have to make sure you timely file for asylum. Do I have to get divorced before filing removal of conditions if the marriage is not working out? So, not necessarily. I mean, if the marriage isn't working out just because you're not compatible, then you're going to have to apply for a divorce waiver. And you have to file for, sometimes divorce takes a while. So if your deadline is coming up, you have to apply, show proof that you filed for divorce, and they'll usually issue a request for evidence asking for the final divorce decree. So make sure you don't miss your deadline to remove the conditions on your green card. Um, so I do see that your spouse is a citizen. So if your spouse is a citizen, you cannot include your child on the same application. It has to be a separate application. Now, if your child was 18 already at the time you got married, he does not even qualify as a step parent for immigration purposes. So this is where it's very important to just follow up, because remember, I don't know your case. I haven't read your file. I don't know anything about it, and I'm not your attorney. But based on the facts you've given me here, it appears that there may be a complication with that. You go ahead, schedule an appointment, and we can talk more in detail about it, because it sounds like you need assistance. Um, so thanks for your help, and you have a lovely day. You too. Can my spouse come to the U.S. from Nigeria once we get married, or or how and when should we start the process? Diamond, give me a call. I do have clients who are in the same situation and who thought the same thing, that they could just get married and then bring their spouse to the US from Nigeria. Unfortunately, if you're if you're thinking it's just as simple as him getting a visa to come, you're in for a rude awakening. So it's not that way. You with the process, as soon as you get married, you have to file what's called an I-130 petition with evidence of your bona fide marriage. The whole process takes about 2 years, and I can guide you through the process, because I do have clients who are in Nigeria right now going through the same thing that I think you're going through, or you will go through. All right, so I have time for one more question, or two more questions, and then I'll head out, and I will be back. Just I'm gonna miss everyone. I'm gonna miss all of you, but I will continue to just post videos, and then try to come on where I can. But so just follow me, subscribe, and then we will touch base whenever I can in the next 2 weeks. What happens when a person with removal of conditions get a divorce before getting an approval, married 4 years? then in that case, it's so important to switch to VAWA. So VAWA does exist with this. VAWA or a divorce waiver. It just depends. With VAWA, if there was mistreatment. If there was no mistreatment, then at that point it's going to be a divorce waiver along with showing that your marriage is real. But what you do have to do, what's important is if you're in the middle of the removal of conditions, the worst thing you can do is do nothing. You need to switch it to a waiver. Whatever waiver, whether the divorce waiver or the VAWA waiver or the extreme hardship waiver, you must do that. And I do help my clients to make that transition quickly so that there are no complications in the process. Okay, so what's the difference between citizens and permanent residents? A permanent resident is they're given permission to live here, and they have to renew their residence every 10 years. They can't vote, so they don't have a say in the government. They can't vote, and they should never say they're a citizen. While citizens, they have the right to do have they have certain rights that permanent residents don't, like the ability to vote. They can access certain federal jobs because they're citizens. So those are some, and they can travel outside of the US and live outside of the US for however long they want and come back to the country and still enjoy the privileges of being a citizen. They can travel to so many different countries without a visa, whereas permanent residents, while you get permission to live here, you can't vote, you can't leave the country for more than a certain amount of time without losing your permanent resident status. So permanent residence is like permission for you to be here, but you don't have the privileges that a naturalized citizen would have or a born citizen would have. All right. So if you're going to a Stokes interview, would it be better to have your attorney come in person, or it's the same if they participate via phone? So you have to be careful about that. If you got prior permission to do it by phone, great. But in some cases, I've heard of situations where the officer will not make that call. They will not make the call to the attorney, and you'd be on your own. So I highly suggest, highly, highly suggest that your attorney is present, but it's going to depend on your attorney and the arrangements. If your attorney has made a prior arrangement with the immigration and they've confirmed this, then sure. But I always, for me as the attorney, I want to be present, physically present, because it's never really even the same over the phone. I mean, you can't see what's going on. You can't get a feel for, what how is the situation playing out. So it's difficult, for me to do it via phone. And then now that the COVID emergency is done, that's another thing, is the officer going to even, you know, grant that request to do it by phone? If your spouse is unemployed, can he still file for you to come to the US? Yeah, sure, but he's going to need a joint sponsor. Um, he has his naturalization certificate, but has been here since he's 12. So yep, so if he's a citizen, then there are going to be issues with sponsoring your child. All right. Thanks so much, everyone, for your time. Remember, while I will not be making appearances here on the live, we're still taking consultations. So go ahead, book your consultation. If you really do need to get assistance from me, go ahead and do that. I'm still available to speak with you in those consultations, but it's just for the next 2 weeks. I will not be able to come on here regularly, but I'm still going to make stops in live as much as I can. And I'll also release videos just keeping you updated about, what's going on in the immigration world. All right. Have a good day. Uh, I'll see you soon. You're welcome. Have a good day. All right. Bye bye.